don't understand this ABC.
What? So, Virginia is, it has a very regulated liquor market.
I tell you what, we'll talk about this later.
Down there, over here, perhaps.
That's the.
Allegedly.
You guys better both stay here.
All right, I'll shoot wide. You should try.
Yeah,
exactly.
So then
Okay, we'll talk about it later. I think we're gonna have enough time.
I don't know. And something to for friends. Do you have it still?
My wife was like, it's like kissing my uncle.
No. You actually look good at it. Mustache? Yeah. You look like a firefighter. Yeah.
Guys had a beard and
Andrew Renison works over here now. Has a bad neighborhood. Do you know Andrew Renison?
Oh, Kenworth. Yeah, it's
He's cop now.
it's a cop.
Yeah, he's a DC cop.
DC cop or Capitol Hill cop?
I don't know.
There's like 14 police. Yeah.
Yeah. He was living in Nairobi. He was like a New York Times like protege.
Oh yeah.
Was like the Getty
Just
protege.
had enough.
Now
Yeah.
Police officer.
Now he's a police officer. He's like, I'm out, I'm done. I'm quitting journalism. I'm becoming a police officer.
Smart move.
Isn't that Doug Jones again? No, who's that? Is that Doug
Yeah,
Jones?
that's okay.
Okay.
Morning. How are you feeling today? Very good, thank you. That was easy. If everything goes like that, we're good. Yeah. We hope so. Right, I know. Yes, sir. Someone said you were looking for me.
Yeah, I was just gonna ask about the press that weren't in the stand. If it takes that.
Am I having a shot here?
If you're okay, yeah, it's kind of a small space.
Let me see if I can get here. And then I'll get them.
Did she come this way? Yeah.
Yeah.
You gotta get the press inside the stand.
So, you ready? ABC?
Almost. They're going back.
Yes.
You going back. You got it. So far. Is
You said
Go,
that.
you can have a seat.
You're gonna have to be.
Cause I'll stand.
Hillary was.
Yeah,
Hillary was.
but I'll stand. No, I'll stand. You have a seat, bro. I'm good. I'm good. You take seat. I'm chilling.
You let
I
me
run
know.
now. Runner.
You what? Are you
I'm
gonna
a
put one
marathon
on the
runner. I
sides
can
and
stand
stuff?
up.
No.
She sneak right up on you.
No,
I'm gonna bend down too. I'll just,
You, Michael?
What?
Go ahead.
No. You just got here. What are you talking
oh
about?
yeah,
I don't know
absolutely.
who this is.
I don't know whose it is either, so I think it's all good
My
now.
God.
Our producers.
Oh man. That's your bone.
Here, I'll get out of your hair while you here, watch out.
I'm just gonna get this out of the way.
Thank you. I'm gonna sink back in here. And I'll just chill out here. Are you good like that?
Yeah.
Okay, I'm good. Probably really good.
You'll be
For
good.
half an hour, so I'm gonna stand.
I'm close to having.
Yeah, I'm just gonna go ahead and let my knees.
All right, so, you know, the Virginia ABC stores are highly regulated. They're government controlled. So typically, you know, you can't get something that's in demand for market value anywhere else because it's ABC. There's a lottery system for, you know, like 1,200 of these bottles that go for $900, $10,000, you know, $1,000.
Problem with editing on your phone is you can't.
You never heard of Pappy Van Winkle? Oh man, it's like wild. It goes for hundreds and hundreds of dollars.
How big a bottle?
Sometimes thousands of dollars.
How big?
I mean,
How big? A bottle.
Like fifth, a pint, gallon.
It's a gallon of bourbon.
I'll come back in 10 minutes.
750 milliliters.
I appreciate that.
So you can get it for $80. You put, yeah, then you sell it for $900.
Yeah, that explains why on occasion you see long lines outside of Virginia ABC.
Probably.
Like when there's many plants, like 60 people. I was like,
Probably not.
you guys wait till this is some bourbon the other day.
Keep walking. Don't worry about it.
They have meetings.
Yeah.
Just doesn't
Yeah.
change the taste from all during shot.
Yeah. It's true.
No.
It's really like, it's in there where it's.
Yeah,
It's like,
true.
she's seen it reasonably back then, so that's good.
Yeah.
Person, that's that.
Miss all the action.
I was mad about it. I was like,
I
"You're
know.
gonna come break me now?" Like, when I find somehow that.
Especially as soon as that moves up. It could be hard to watch right.
I was living this thing already. I was like, really?
But the next time she,
Oh, yeah.
when she,
I could see that. Virginia.
you're there.
You know, what's DC? Oh, yeah.
I'm familiar with it.
Yeah.
Gummies,
I might have with them.
cigarettes. You can just go to the store and buy it. Wow.
Yeah.
But if she goes to the room, she still has to come back this way anyway, right?
She'll come back.
Yeah. Andy, what do you think when she comes back, she's just going straight? Yonder? Or yonder?
She'll probably, where did she come out?
She came out of there.
She came out of this way.
Usually go.
Right. The lane.
You know what? Maybe we'll go high and then go low. I just
Cool,
want to see
cool.
you standing. Jump up here. Right?
Who are you today?
What's up? Greg, let's go. What's up, man? Yeah, literally. Yeah, has she been in here? Oh, no, no.
Hey, girlfriend. All right. Got it. How come you're in a bad mood with that face? So happy.
Oh, behind this is just anger.
No, I know.
pressure.
Yeah, depression.
Yeah, yeah.
No, you're not.
You're okay. Yeah. You might even be okay to stand up.
One professional photo, I've seen it.
Already got rid of sound already, so you know, like this.
So after she does that, maybe she come out again and say like a lunch break.
Probably.
So we just don't know when that is.
You don't know what that is. I mean, they'll say it from there. Like Durbin will be like, we're now resourcing for an hour,
Okay.
but you have to pay attention. Yeah, we'll like release this. Like definitely one. Maybe even another time. Yeah, exactly. So especially like tomorrow when it's
There's been one component of the American society that has never sat in the chair that would equal to them becoming a member of the United States Supreme Court. That has been a black woman. I expect to hear a qualified, well-tempered, brilliant jurist sit before the Judiciary Committee who happens to be gladly and excitedly an African American woman, confident, sure in her profession, and committed to the values of the Constitution, a patriot. And besides listening to very erudite legal answers, there will be a high degree of emotion for how she started and where she is today. We are still in a nation that is, unfortunately, dictates to certain groups an unequal status. Her presence here today indicates that we all are created equal with certain inalienable rights of life and liberty and the pursuit of happiness.
And then what's your reaction to Senator Hawley's comments that Judge Jackson has a pattern of letting sex offenders off the hook? Do you think that these comments are appropriate? What's your reaction to that?
If I took his comments seriously, I'd be outraged. But they are hollow. They're not worthy of dignity and respect. They are inconsequential because obviously he doesn't know that lawyers take an oath. Their responsibility is to defend those who come to them. As a federal public defender, she was assigned the work for these cases, and she did it from an appellate perspective. She did the appeal work, and she did it excellently. We know in this business, as a lawyer, that it is our responsibility to defend our clients to the fullest of the law, no less and no more. Judge Brown Jackson did that ably. Again, if I was to take Senator Hawley's comments seriously, I would express outrage and indignation. But I think it's important to say that his comments are irrelevant, senseless, poor taste, and a complete lack of knowledge. In fact, ignorance of the responsibilities of a trained lawyer who has taken an oath, passed the bar, and given a responsibility to defend defendants to the fullest extent of the law, within the confines of the law, within the confines of the Constitution. And that is what the judge did at the time that she represented these individuals.
Thank you so much.
Thank you.
Morning, everybody.
Morning. How are you?
Good.
She came in the elevator and came out.
I did interviews with him.
So, yeah, that's the, so she has
Better move that.
I'll stay over here for your guys. I think we need to, once they're all in, I'll just use one.
So they just meet at the top of the order, or is it meet?
Looks like I'm,
what do they mean? So, sound like I'm close.
Let me see if what else they requested at that time. Yeah, they're taking Ariana.
You guys are all with the press. You'd be inside the stanchions. Stanchions over here.
That's
or
fine.
over
No
there.
worries. It's okay. Are you?
They're taking Joe, but Joe missed it. And Laura's on that panel too. I think that you're doing it at the top and then, Ariana's almost. It just doesn't.
Oh, yeah.
And then I think.
Oh, Ariana and I both.
It doesn't say, but we both requested for very top. And then they requested a panel with, Lauren. don't know that I want to. I don't really feel aligned.
That when you graduated,
Let's go with that.
here's Evan. Upstairs.
Oh, he's in.
Yeah, he's upstairs.
Yeah, they're like, they have the window closed, so he'll be up there all day. Nice. The booths, you can. Booths you can be in all day. We had to draw for them last week. You can even like which booth who gets which booth. Yeah, it's basically like a raffle. Just wait. Everyone gets one. It's just a question of which one you get, which is to say, like, there's Cornyn. Kennedy.
Yeah. Oh, yeah.
So, Cornyn, you think you might go for him?
Okay, cool.
You can note it whenever you send your next acceptance note. Yeah, I would send them those. Right, but you could be like.
Is that the network?
No, it's yeah, we're going to aim for her opening remarks.
Step aside. Thank you. Hard hitting stuff. My life.
Hey, everybody. How open minds are you supporting her nomination?
Imagine. All right. That's fake.
That's what,
What's that?
what do you want to hear from the judge today?
Well, there's lots to talk about.
Would you mind stepping to the mic?
Okay, all right, real quick. I don't wanna- this will be the beginning. Obviously, we've got several days of hearings here. I've laid out some of my concerns. I imagine other committee members will want to talk about, am I too close to you? I imagine other committee members will want to talk about, I'm like right up on this camera. We'll want to talk about other issues, but listen, I want to hear about her record, beginning with her record on crime, why she's sentenced below the federal guidelines, why she's sentenced below what the government's recommendations were in child porn cases in particular. And I imagine there'll be lots of questions. So it's 3 days of hearings, 2 days of questions. So we'll see. I kind of feel bad for her this morning, though. She has to sit there and listen to all of these opening statements. That's going to be the most painful part for her, probably. It's in the next few hours.
And any comments on how you also voted to confirm 3 federal judges that have also imposed lighter sentences for child porn offenders?
Not for this job, I sure haven't. Not for this job. So we'll see. All right, thanks, guys.
He's gonna have something to say. He's gonna try to.
Okay, okay. I know they wanted to see it, but at the same time, it's like, we're not really getting point stuff. Now, is it one daughter? Yeah, daughter.
And hearing about you guys from meetings. Thank you. Excited for today?
I was just doing based on the outfit.
Can you make sure you don't move? Yes.
Here she comes.
Good morning. Piece of advice you can give. Yeah, I know.
Huh? Yeah, I think so.
Nice work. Nice work.
My hands getting tired for opening up that door.
I got a little carpal tunnel, right? There you go.
That's the way.
This hearing of the Senate Judiciary Committee will come to order. Today, the committee will begin its consideration of the nomination of Judge Ketanji Brown Jackson to be the 116th Justice of the United States Supreme Court. Welcome, Judge Jackson, and congratulations to you and your family.
Thank you, Senator.
This is a momentous occasion, and you have much to be proud of. I know you have many family members and friends who you want to introduce, and we all look forward to hearing those introductions when you make your opening statement later. At the outset, I want to note that I was sorry to hear that Justice Clarence Thomas was hospitalized yesterday. I'm sure I speak for all the members of the committee in wishing him a speedy recovery. Before I turn to my own opening statement, I want to briefly discuss today's order of events and the ground rules for the hearing. Today, each member of the committee has 10 minutes to make an opening statement. We'll go in seniority order, switching between Democratic and Republican senators. After all members have made their opening statements, we'll hear from Judge Thomas Griffith and Professor Lisa Fairfax, who are here today to introduce Judge Jackson. Each introducer will have 5 minutes to make an opening statement. Finally, we'll administer the oath to Judge Jackson, and she will make her opening statement, and that will conclude today's events. Tomorrow, we'll begin rounds of questions. For those sitting in the audience, welcome. We are glad you could be here to witness this historic occasion. I ask all of our guests to be respectful and quiet during the hearing. Please do not stand up unless you're entering or exiting the room. And if you stand up, you will be asked by one of our distinguished members of the Capitol Police to sit down. If you refuse, you'll be escorted out of the room. Let me be clear. We will not tolerate any disruptions from the audience. Any disruption will result in immediate removal. I also ask that our audience be respectful of the members of the Capitol Police who are here today to ensure everyone's safety. With that, we'll proceed to opening statements. Judge Jackson, as I said, thank you again for being here today with your family and friends. The Supreme Court has a long and storied history. Its ranks have been filled by many superb justices whose contributions to the rule of law have stood the test of time. But the reality is that the court's members, in one respect, have never really reflected the nation they served. When the Supreme Court met for the very first time in February of 1790 in the Exchange Building in New York, there were nearly 700,000 slaves without the right of citizenship in this new nation of nearly 4 million people. Neither African Americans nor women had the right to vote. There was no equal justice under the law for a majority of people living in America. In its more than 230 years, the Supreme Court has had 115 justices. 108 have been white men. Just 2 justices have been men of color. Only 5 women have served on the court, and just 1 a woman of color. Not a single justice has been a black woman. You, Judge Jackson, can be the first. It's not easy being the first. Often you have to be the best, in some ways the bravest. Many are not prepared to face that kind of heat, that kind of scrutiny, that ordeal in the glare of the national spotlight. But your presence here today, your willingness to brave this process will give inspiration to millions of Americans who see themselves in you. As I mentioned to you, I was at the steps of the Supreme Court this morning to see the rally in support of you. There were so many young African-American women students there seeing your pursuit as part of their dream. In other important ways, though, they're no different than many nominees who've come before us. President Biden nominated you because he knew your qualifications are outstanding. This committee knows you. You've appeared 3 previous times, and each time you've been confirmed with bipartisan support. And your professional record and life experience tell us what kind of lawyer, what kind of judge, and what kind of person you really are. Your guiding principles can be found in your life and in your work. That the Constitution must work for all Americans, not just the wealthy and powerful. That judges must show no favoritism, and that the judiciary must live up to the words emblazoned above the entrance: equal justice under law. So today is a proud day for America. We've come a long way since 1790, and we know that we still have a long way to go to form a more perfect union. It's a moment that brings to mind something that the late Senator from Illinois, Paul Simon, my friend, said to Judge Ruth Bader Ginsburg at her nomination hearing. He said, you face a much harsher judge than this committee, and that is the judgment of history. And that judgment is likely to revolve around the question, did she restrict freedom or did she expand it? I return to this statement time and again because it asks a vital question. How will history judge us? Judge Jackson, I have no doubt that history will remember you as a justice who never stopped working to defend the Constitution. But I also ask the members of this committee, as we begin this landmark confirmation process, to consider how history will judge each senator as we face our constitutional responsibility to advise and consent. This moment also brings to mind something President Barack Obama, another trailblazer, said of a fellow Illinoisan when the late Justice John Paul Stevens announced his retirement. President Obama said, "While we cannot replace Justice Stevens' experience or wisdom, I will seek someone with similar qualities, an independent mind, a record of excellence and integrity, a fierce dedication to the rule of law, and a keen understanding of how the law affects the daily lives of America. Much like Justice Stevens, we cannot replace Justice Breyer. But with you, Judge Jackson, we have a nominee who embodies the same qualities as both of these outstanding justices. You're independent-minded and understand the critical importance of judicial independence. Your record is one of excellence and integrity, from the championship debate team at Miami Palmetto Senior High School to Harvard and Harvard Law School, to your 3 judicial clerkships, your work as a federal public defender, a lawyer in private practice, a member of the Sentencing Commission, a federal district judge, and circuit court judge. Throughout your career, you've been a champion for the rule of law, determined to get it right, even at the risk of public criticism. As a member of the United States Sentencing Commission, a bipartisan group which reflected the spectrum of American thinking on law enforcement, you set out to make policy that truly represented congressional intent when it came to making federal criminal sentencing fairer. And you did it by finding bipartisan common ground. During your tenure on that commission, 95% of the commission's votes were either unanimous or consensus. For example, the commission implemented the Fair Sentencing Act, a law that I negotiated with then Senator Jeff Sessions that reduced the infamous 100-to-1 crack powder sentencing disparity. And you joined every one of your colleagues to make that change to the sentencing guidelines retroactive. You gave a powerful speech, and I'm going to quote it. You said, "There is no excuse for insisting that those who set excessive sentences under the long disputed and now discredited prior guideline must carry on as though none of this has happened." The vote in favor of retroactivity was unanimous on the commission. Republicans and Democrats shared your view. And you've gone to great lengths to explain how the law affects for prosecutors and for defendants. You've ruled for workers and for their employers, and you've been faithful to the law, not to any person or political cause. Now, there may be others who allege that you're before us today as a product of the campaign of dark money groups. Once again, your record and the process that led to this nomination belie that claim. To suggest that you're here merely because an organization supports you ignores your qualifications and the broad range of support you bring to this. In selecting you as his nominee, President Biden undertook a transparent selection process. He sought the input of senators from both parties. Senator Grassley and I met in the Oval Room with the president. He invited us to proffer any nominees that we cared to do. At the end of the day, the president alone chose you. He's put his faith in you to deliver justice at the highest level of the court. I share that faith. In announcing your nomination, the president spoke to many reasons that you deserve to sit on the high court. He noted the perspective you'll bring as a former member of the Sentencing Commission, as the first justice since Thurgood Marshall with considerable criminal defense experience, and as the second current justice, only the second, to serve as a federal trial court judge. He also noted your upbringing and the fact that you come from a law enforcement family. Yet despite that shared family experience, despite your record, we've heard claims that you are, quote, soft on crime. These baseless charges are unfair. A conservative National Review columnist called claims brought by one of my colleagues, quote, meritless to the point of demagoguery. They fly in the face of pledges my colleagues made that they would approach your nomination with civility and respect. And fact checkers, including the Washington Post, ABC News, and CNN, have exposed some of these charges as falsehoods. Critics have even stooped to accusing you of sharing the views of the clients you represented, even though they know that your work as an attorney was in service to the Bill of Rights and the Constitution's promise of effective assistance of counsel. Would law enforcement officials and organizations, including the International Association of Chiefs of Police, the National Organization of Black Law Enforcement Executives, and the Fraternal Order of Police have endorsed your nomination if you were soft on crime? Of course not. I'm confident the American people will see through these attacks and any other last-minute attempts to derail your confirmation. In closing, I want to share the words of one more Illinoisan, if you bear with me, a rather famous one named Abraham Lincoln. In August 1864, at the height of the Civil War, President Lincoln addressed the 166th Ohio Regiment. Lincoln said to the soldiers, and I quote, "I happen temporarily to occupy this big White House. I am living witness that one of your children may look to come here as my father's child has. Judge Jackson, we are all just temporary occupants of the Senate, the House, even with a lifetime appointment to the highest court in the land. You, Judge Jackson, are one of Mr. Lincoln's living witnesses of an America that is unafraid of challenge, willing to risk change, confident of the basic goodness of our citizens. And you are living witness to the fact that in America, all is possible." I now recognize my colleague and friend, the ranking member, Senator Grassley.
Judge Jackson, congratulations. Welcome to you and your family. I thank you for taking time to visit with me in my office after the president nominated you. Since President Biden announced his nominee for the Supreme Court, I've been encouraging my colleagues to schedule meetings with you, Judge Jackson, and they have come off. In addition, I've continually emphasized the need for a thorough, respectful process by the committee. Now I want to talk a bit about what everyone watching should expect from this hearing and what they shouldn't expect at the hearing. We will conduct a thorough, exhaustive examination of Judge Jackson's record and views. We won't try to turn this into a spectacle based upon alleged process fouls. Good news on that front, we're off to a very good start. Unlike the start to the Kavanaugh hearings, we didn't have repeated choreographed interruptions of Chairman Durbin during his opening statements, like Democrats interrupted me for more than an hour during my opening statement on the Kavanaugh hearings. What we will do, however, is ask tough questions about Judge Jackson's judicial philosophy. In any Supreme Court nomination, the most important thing that I look for is the nominee's view of the law, judicial philosophy, and view on the role of a judge in our constitutional system. I'll be looking to see whether Judge Jackson is committed to the Constitution as originally understood. We all know there's a difference of opinion about the role judges should play. Some of us believe that judges are supposed to interpret the law as it was understood when written, not make new law or simply fill in vacuum. Those of us who share that view think that under our Constitution, Congress and not the federal courts are given the authority to make law and to set policy. Now, there are others who believe that the courts should make policy. They believe in a so-called living constitution. They think that the Constitution's text and structure don't limit what a judge can do. To them, deciding what the Constitution means is really a quote-unquote value judgment. Under that approach, judges can exercise their own independent value judgments. One of the leading advocates for this approach explained that as a judge, you, quote, reach the answer that essentially your values tell you to reach, end of quote. In other words, those who subscribe to this philosophy think that the founders really meant to hide elephants in mouse holes. Then, with a bit of creativity, these judges can always find that elephant. That sounds like a good job description instead for legislators and not for judges. But for at least 4 years, Democrats systematically voted against many well-credentialed nominees that were diverse professionally, diverse geographically, diverse religiously, and diverse ethnically. Was it racist or anti-women for them to do so? I don't believe that it was. Democrats did it because the nominees didn't agree with living constitutionalism, just as Republicans have opposed nominees based upon their judicial philosophy. There are lots of problems with living constitutionalism. In the Senate, we spend a lot of time writing legislation. We argue over the language. We negotiate over how broad or narrow certain provisions of laws should be. If we can't convince our colleagues to adopt all of our ideas, we have been known to compromise every once in a while. We depend on judges to interpret laws as we write them. If judges impose their own policy preferences from the bench and essentially revise the laws we pass, it makes it harder for us to write good laws. Sometimes we need to include a provision that's very broad to get a colleague's support. If a judge rewrites the law later because of vague notions about fairness or equity or common good, that unravels all of our work here in the Congress. More importantly, the American people should be able to read a law and know what it means. They shouldn't have to ask how a federal judge who disagrees with the law could reinterpret the words on that page. All of this leads to the conclusion as to why we must carefully examine federal judges' records, especially Supreme Court nominees. Judge Jackson has served as an assistant public defender, worked in private practice, and served on the United States Sentencing Commission. She also served as a federal district court judge from 2013 to 2021. She served on the DC Circuit since June last year. I'm sure senators will have a few questions for Judge Jackson about the 2 opinions she's authored since joining the DC Circuit. As for her district court record, there have been some accusations that we cherry-pick some of Judge Jackson's criminal cases. Well, don't worry. We're going to talk about other cases as well. I was disappointed that we weren't able to get bipartisan agreement to ask for Judge Jackson's documents from her time as vice chair of the Sentencing Commission. The commission is an independent agency created to advise and assist Congress and the executive branch in the development of effective and efficient crime policy. And that's a quote. Unfortunately, it sounds like we'll have to wait until those documents are required to be released, and that will be about 20 years from now. Democrats have argued for time. Democrats have argued that Judge Jackson's time on the commission is an important part of her experience that she'll draw on as a judge. The Democrats are right on that point. That's why it would have been good to see what her views were as the head of the commission. Explained in a letter to Senator Durbin, the public documents turned over to this committee represent the consensus views of the commission and not necessarily Judge Jackson's own views. The Obama White House sent us roughly 68,000 pages of material, but more than 38,000 of the 68,000 pages are repeated copies of emails, threads that keeping track of the tweets about the Garland nomination. Those emails contain just one tweet about Judge Jackson. More than 13,000 of the 68,000 pages are just lists of previous nominations. So that leaves only 16,000 of 68,000 that we received from the White House that aren't obviously useless like all the other documents received. But for comparison, the White House has still withheld 48,000 pages under the presidential records and FOIA exemptions. Now that's a lot of hiding, but the limited number of useful records that we received from the Obama White House show exactly why the Sentencing Commission documents would have been important. There are a number of dark money groups on the left that argue federal judges should make policy decisions based on judges' own values. I've talked about the troubling role of far-left dark money groups like Demand Justice have played in this administration's judicial selection process. When the Demand Justice isn't creating short lists for President Biden to pick judicial nominees from or putting out new litmus tests, they're running ads campaigns attacking the independence of the judiciary. They've strongly supported the so-called progressive prosecutors who are soft on violent crime in the face of rising crime waves in cities like San Francisco, Philadelphia, Boston, and Los Angeles. Now, what does that have to do with the nominee before us? The Obama White House records indicate that a co-founder of the Demand Justice played an important role in Judge Jackson's nomination to the Sentencing Commission and the District Court. The Demand Justice co-founder even interviewed Judge Jackson about the nomination to the Sentencing Commission. It would be helpful to know what Demand Justice co-founder learned from that process and why they strongly support Judge Jackson. However, it isn't all been bad on the document front, I want to make clear. We'd asked for briefs that aren't available online for DC Circuit cases Judge Jackson worked on as an attorney. At first, we were told they might not be available for a few weeks, but to our pleasant surprise, we received them early, apparently because the White House had asked for the documents as well. Judging by timetable, we were originally given to get the briefs. That request was made after she was announced. Now those documents concern Judge Jackson's time as assistant federal public defender. Democrats have accused Republicans of vilifying nominees who have represented criminal defendants. That's just not the case, and I think that's a very unfair accusation. Previous Supreme Court nominees have also represented criminal defendants on appeals. Chief Justice Roberts was appointed by the Supreme Court to represent a defendant in an important criminal law case, and he also helped represent an inmate in a Florida death row. And Justice Barrett represented a criminal defendant appealing their conviction while she was in private practice. Now, I've distinguished between two types of nominees who have worked in criminal cases. There are Bill of Rights attorneys who want to protect defendants' constitutional rights. Then there are what I've called criminal defense lawyers who disagree with our criminal laws. They want to undermine laws that they have policy disagreements with. And of course, that's a very important difference. Just a year ago, no, maybe it's now 2 years ago, Democrats had no trouble opposing nominees based on arguments these nominees made on behalf of clients. I could read off quotes of Democrats doing that to Trump nominees, but we only have a few minutes for these opening statements, and I'd run out of time. On a final note, during Justice Barrett's confirmation hearing, Democrats said that she would, quote unquote, judicial torpedo, aiming at protections for pre-existing conditions. We heard that argument repeatedly. Conservatives and anyone who actually looked at her record and laws said that that was strictly nonsense. But Democrats were sure otherwise. Well, when that case was finally decided, Democrats were proven wrong. I'm sure that won't deter any of my Democrat colleagues from making some confident predictions this time around as well. But the public record should remember their track record and perhaps take those claims with a grain of salt. They were wrong in their strong declarations how Justice Barrett would rule. Judge Jackson, congratulations on your nomination. I look forward to hearing from you about your record, your views on the law, and your judicial philosophy. Thank you.
Thanks, Senator Grassley. Next is the President Pro Tem of the Senate and former Chairman of the committee, Patrick Leahy.
Well, thank you, Mr. Chair. And Judge Jackson, welcome. It's really good to see you again. You know, today and actually throughout this week, the committee and the country are going to hear from Judge Jackson. She's been nominated to be the next Associate Justice of the United States Supreme Court. Any nomination of the court is historic. There have only been 115 justices in our nation's history. Judge Jackson's nomination, of course, is historic in more ways than one. Her nomination, pending a confirmation by the Senate, will bring us one step closer to having a Supreme Court that is more reflective of our nation. One where diversity of race and gender, background, education, and experience allow all Americans to look to their court and see in its justices a reflection of the American people. Judge Jackson, you know, with your presence here today, you are writing a new page in the history of America, a good page. Who the president nominates and the Senate decides to confirm to our federal judiciary, and especially our nation's highest court, that's extremely important. The American people, our constituents, and their faith in the courts, that's central to our democracy. They lose that faith, then democracy loses. The decisions made in our courts and ultimately in the Supreme Court affect the daily lives of each one of us. Fundamental questions about, for example, access to health care, the integrity of our elections, the fairness of our criminal justice system, the preservation of bedrock environmental laws, protections for workers. These issues and many more are routinely decided by the court. Every American must believe that the court is going to be impartial. They must believe that our courts are not a mere political arm of the executive or the Congress, but faithful only to the rule of law. The stakes in a democracy are simply too high. Let's make a few things clear. Judge Jackson is known judicial activist. She is not a puppet of the so-called radical left. She's been praised by Republican-appointed judges for her jurisprudence. Lawyers from the right and the left who have appeared before her in court have called her judicious and even-handed. Before I was in the Senate, I tried a lot of cases in trial court and then courts of appeal. That's what I wanted, somebody who was judicious and even-handed. I didn't care what their politics were. Judge Jackson is not anti-law enforcement. She hails from a law enforcement family. She's also won the support of preeminent national law enforcement organizations, including the National Fraternal Order of Police. And no, she's not soft on crime. Her background as a federal public defender would bring an informed perspective of our criminal justice system to the Supreme Court. I'm proud of being a former prosecutor, but confidence in my prosecution of a case was strongest when I knew the defendant had the best possible representation. When both sides and the presiding judge have a real grasp of our criminal justice system, that's when justice is most likely to be done. So I would say that Judge Jackson's background is not a liability to the court. It's a much needed asset to the court. And since her nomination, again here today, we've heard about the long distinguished record of Judge Jackson, graduate of Harvard, Harvard Law School, a judicial clerk at the district, circuit, and Supreme Court level, a federal appellate judge, a federal district court judge, a member of the U.S. Sentencing Commission, an attorney in private practice, and a federal public defender. What a resume. All these experiences and perspectives have provided her a mastery of our justice system. And I'd say in particular the criminal justice system. If she is confirmed, she would become the first ever justice to have served as a federal public defender. That's an important experience given how much the court shapes our criminal justice system. I say that from my experience as a senator, but also my experience for nearly a decade as a prosecutor. And perhaps most of all, it is Judge Jackson's nearly 10 years as an appellate and trial judge to underscore the experience she would bring to the Supreme Court. She was confirmed unanimously by the Senate in 2013 to the D.C. Circuit Court. She served with distinction for 8 years. She issued more than 500 opinions. She presided over a dozen trials. And a bipartisan majority of the Senate confirmed her to the D.C. Circuit Court of Appeals last year. Let's be honest, she's a fair and impartial jurist with a fidelity to the law above all else. That's what Americans want to see in the Supreme Court justice. Years of so-called judicial wars have left Americans feeling like our courts have become increasingly partisan. The extreme interests of pressure groups on both sides of the political spectrum have left the American people wondering if they can get a fair shake in our courts. And yet, in this moment, we have before us a unique opportunity to change that narrative. I'm under no illusion that we can mend this process overnight. But we have before us a nominee who has brought us together across party lines before, and one I hope we can bring us back together again. The Senate can change course, return to how we fairly and objectively evaluate nominees. We can do that with a highly qualified nominee we have in Judge Jackson. Now, as Chair Durbin said, I'm the president pro tempore of the Senate. I'm a former chairman of this committee. I've participated in 20 prior Supreme Court nomination processes, most leading to confirmation, a small handful not. In fact, the first justice I voted on was from your state, Senator Durbin, John Paul Stevens. I've supported nominees from both Democratic and Republican presidents. And in Judge Jackson, I found a distinguished nominee with an unassailable record that merits our respect regardless of party. I believe the American people will see in her what I've come to learn in my review of her career and her life story. Her nomination is a reflection of the arc of our democracy. The arc that bends towards justice, as Dr. King once said. Although in fits and starts with every generation, we have sought to become more inclusive, more representative. We have looked at citizens, civic leaders, elected representatives, and yes, to judges to strengthen our democracy, and to recognize that our strength comes from our diversity. Judge Jackson's story, her nomination today, is part of the evolving story of America. So Judge Jackson, I want to congratulate you on this nomination. Despite all the darkness in the world, and the political brinksmanship has unfortunately become a hallmark of Congress in recent years, your nomination actually fills me with hope. Hope for the court, hope for the rule of law, hope for the country. One need look no further than the chaos, the devastation, and the inhumanity halfway around the world in Ukraine to know how precious our democracy is and how precious the legacy we have in our independent federal judiciary. I need look no further than my own grandchildren, all of them, to know how necessary our fight for freedom, fairness, and equality is. The independence and impartiality of our courts and of the Supreme Court are a cornerstone of the great experiment that is the United States. And you, the American people, have a nominee in whom they can be proud. We have before us an historic moment, and I hope we can meet it as senators. So I look forward to your testimony. Thank you.
Thank you, Senator Leahy. Next is another former chair of the committee and Senator from South Carolina, Lindsey Graham.
Thank you, Mr. Chairman. Again, congratulations. Well-deserved honor here. You have worked hard all your life, and you have much to be proud of. I have said in the past, and I think it's good for the court to look like America. So count me in on the idea of making the court more diverse. And in the history of our country, we've never had an African-American woman serve on the court. But I also said that didn't get much coverage. I want the court to play a particular role in America. One is make it more look like the country, but also make it operate in the confines of the Constitution. That didn't get a lot of coverage. So the hearings are going to be challenging for you, informative for the public, and respectful by us. I hope we can meet those criteria. It won't be a circus. We're off to a good start. Chairman Grassley couldn't get first word out of his mouth before they shut down the place, so that's off to a good start. Most of us couldn't go back to our offices during Kavanaugh without getting spit on. Hope that doesn't happen to y'all. I don't think it will. As to the historic nature of your appointment, I understand. But when I get lectured about this from my Democratic colleagues, I remember Janice Rogers Brown, the African-American woman that was filibustered by the same people praising you. I remember Miguel Estrada, one of the finest people I ever met, completely wiped out. Didn't make it through the gang of 14, whatever gang I was in. I've been in so many I can't remember. He didn't make the cut. Well-lived life just completely ruined. So if you're Hispanic or African-American conservative, it's about your philosophy. Now it's going to be about the historic nature of the pick. It's going to be about your philosophy. The bottom line here is when it is about philosophy, when it's somebody of color on our side, it's about we're all racist if we ask hard questions. It's not going to fly with us. We're used to it by now, at least I am. So it's not going to matter a bit to any of us. We're going to ask you what we think you need to be asked. And Senator Hawley, you need to ask her about her record as a district court judge. You should. I hope you do. And we'll see what she says. Very fair game. Now, President Biden had a choice here, and he has every right to make it. Elections have consequences. He had many qualified African-American women to choose from. He chose you. Michelle Childs, a judge from South Carolina, supported by Jim Clyburn. That was in the mix. I think it came down to about 2, 3, 4 people. Don't know for sure, but that's what the press was reporting. And when it came to Judge Childs, this Arabella group's in her White House. You talk about dark money, you may be onto something. This Arabella group is funded by Soros and some other liberal billionaire. They got so many groups within their group, I can't name them all now, but they basically said, if you pick Childs, you may have a primary opponent. The FL-CIO said Judge Childs was a union buster. The attacks from the left against Judge Childs was really pretty vicious, to be honest with you. So you say, Judge Jackson, you don't have any judicial philosophy per se. Well, somebody on the left believes you do. Or they wouldn't have spent the money they spent to have you in this chair. So we're going to find out how that statement holds up over time. A viewer's guide to this hearing. She will be asked about her sentencing practices as a district court judge, and she'll have a chance to explain her reasoning, and you can make up for yourself what this means, but it's good to be asked. About her legal views, I'll ask her about the law of armed conflict and her view of the law of armed conflict. The fact that you represent the Gitmo detainees is not a problem with me. Everybody deserves a lawyer. You're doing the country a great service when you defend the most unpopular people. But I do want to know about your amicus briefs after you're no longer a defense counsel weighing into the Supreme Court about how they decide law of war issues. That matters a lot to me. I think it does matter that the groups that came to your aid at the expense of Judge Childs, how did that happen and why were they doing what they were doing? What is it about your nomination that the most liberal people under the umbrella of Arabella threw in their money, their time, their support, and threatened Joe Biden if he picked Judge Childs? I want to know more about that. I want to know about your judicial philosophy, because people on the left, the far extreme part of the left, believe that you were the best bet. And I want to know why they reached that conclusion. Maybe there's no explanation you can give us, but we'll talk about that. Now, when we say this is not Kavanaugh, what do we mean? It means that Democratic senators are not going to have their windows busted by groups. That's what it means. It means that no Republican senator is going to unleash on you an attack about your character when the hearing is virtually over. None of us, I hope, have been sitting on information about you as a person for weeks or months. You come into our offices and we never share it with you to allow you to give your side of the story. We wait to the very last minute when the hearing's about to be gavel concluded and say, oh, by the way, I've got this letter. And so happened that every media outlet in the country had the letter too. So the next morning there were headlines all over the country, really, accusing Judge Kavanaugh of being basically Bill Cosby. None of us are going to do that to you. And if any of us does that to you, all hell will break out. And it should. The media will be your biggest cheerleader. They're in your camp. They have every right to pick who they want to pick. There won't be this constant attack on you like Judge Kavanaugh and other conservative judicial appointments. There won't be any questioning of where you go to church, what kind of groups you're in church, how you decide to raise your kids, what you believe in, how you believe in God. Nobody's going to do that to you. And that's a good thing. So you're the beneficiary of a lot. You're the beneficiary of Republican nominees having their life turned upside down. And it didn't work. So I'm hoping that we can have a hearing that's respectful, that's informative, that's challenging. And President Biden has every right to pick who he'd like to pick. That comes with winning the White House. And I've been very inclined to support the picks. of people that I would not have chosen. But this is a new game for the Supreme Court. And this game is particularly disturbing to me because there's been a wholesale effort of the left to take down a nominee from my state. And I don't like it very much. And if that's the way the game's going to be played, then I'll have a response, and I don't expect it to be reward that way of playing the game. Judge Childs would have gotten 60+ votes. There have been people in my caucus that would have voted for her, even though we knew she would be a reliable liberal vote, because I and Senator Scott would have stepped up. Now we're facing a choice sponsored by the most radical elements of the Democratic Party when it comes to how to be a judge. They have the most radical view of what a judge should do, and you were their choice. And you'll be asked, do you support expanding the Supreme Court? I hope you can give us an answer, because it shouldn't be hard. Either you do or you don't. Justice Ginsburg said no. She thought if you just changed the number of the court every time somebody new came in power, it would ruin the court in the eyes of the public and make it a joke over time. I agree with that. So I hope you can give us an answer to that question, because I think the court would be better off if the judges stood up for the court. If the judges told politicians, don't play this game with the court, because over time, nobody wins. So congratulations. It's going to be a couple of interesting days, and we're off to a better start than we have been in the past. And the one thing I can promise you, you will not be vilified. You will not be attacked for your religious views. You will not be accused of something that you could not defend yourself against until it was too late. Thank you.
Thank you, Senator Graham. Senator Feinstein.
Thanks very much, Mr. Chairman. I want to begin by congratulating you, Judge Jackson, on this appointment. I've reviewed the records of a number of judicial nominees during my service on this committee. This is actually the 10th set of confirmation hearings for a Supreme Court nominee that I've participated in during my time in the Senate. And looking at your record, it's clear that you have the qualifications and the experience and the knowledge needed to serve on the Supreme Court. And as a woman, it makes me very proud of that. As we begin these hearings, we as senators take seriously our constitutional duty to advise the president on his appointment of a new Supreme Court justice. In the current term alone, the Supreme Court is addressing cases on issues that are foundational to who we are as a country. Let me just give you 3 examples. The court is considering a woman's fundamental right to control her own body and make her own healthcare decisions. It is considering the legal authority of the Environmental Protection Agency to fight climate change. And it's considering whether states have the power to enact common sense gun safety protections. As a former mayor, I saw how these problems affect people, everyday people on everyday streets throughout my city and then subsequently the state of California. This is not your first time at this. In fact, it's your 4th time in front of this committee. The full Senate has already confirmed you on a bipartisan basis 3 times to serve as vice chair of the U.S. Sentencing Commission in 2010, as a federal district court judge 2013, and as a federal appellate court judge in 2021. And you have done us proud. Each of the 3 times, the Senate has considered your record, your experience, and your ability. Senators on both sides of the aisle have determined that you have the qualifications and the temperament it takes to uphold the values of our judicial branch. As I see it, Those values are knowledge, even-handedness, impartiality, integrity, respect for the rule of law, and fundamental fairness to all. And your record actually shows that you exemplify these values. The Supreme Court is not a political institution. Rather, the court stands above politics and above partisanship, and we look to federal judges to be independent and unbiased. Judge Jackson, in reviewing your record, one thing in particular stands out to me, and that's your commitment to uphold justice under the law. This is one of the ultimate responsibilities of the Supreme Court, and your record suggests to me that you understand the weight of that responsibility. You've had several mentors early in your career who I understand were important in instilling these values in you as a young lawyer. One of those mentors were Justice Stephen Breyer, who you served as a law clerk and to whose seat on the Supreme Court you have now been nominated. What a treat for you to see that happen, and I know for him as well. Justice Breyer has been a thoughtful and even-handed judge throughout his career. So you have learned from the best, and you have brought those lessons and that dedication to equal justice with you throughout your career in the law. You have strong credentials. You're a graduate of both Harvard University and Harvard Law School, a former Supreme Court clerk, and you have served as a federal judge for 9 years, most recently on the U.S. Court of Appeals for the District Circuit. These are impressive credentials, and they are also familiar to those of us who have reviewed numerous nominees to the court. But you also bring experiences that are less common, especially at the Supreme Court. The first is your service as a federal public defender earlier in your career. If you were confirmed, you would be the first ever federal public defender to sit on the court, and the first justice since Thurgood Marshall with significant experience representing low-income defendants and criminal cases. I believe this is very significant and important because as a former public defender, you understand the power of our constitutional rights, including the Sixth Amendment right to counsel and the Fifth Amendment right to due process. You also understand the effect of law and the law enforcement system on the most vulnerable. And I believe your 8 years of expertise as a trial judge on the DC District Court is very valuable. So, if confirmed, you would be one of only 2 former federal district court judges serving on the court, the other being Justice Sotomayor. I believe your perspective as a former trial judge will serve you well on the court. You've been responsible for implementing the precedent set by higher courts. And because of that, you understand the need for clarity in legal opinions, for achieving consensus wherever consensus is possible. And that has been your record. It's important to have justices with a broad set of views and experiences on the Supreme Court. And I believe your background and your experience will only serve to strengthen the Supreme Court. I trust that my colleagues on this committee will recognize that you are unquestionably qualified for this position. I wish you well. I look forward to learning more about you over the course of the coming days. Thank you, Mr. Chairman.
Thanks, Senator Feinstein. Senator Cornyn of Texas.
Thank you, Mr. Chairman. Judge Jackson, let me join my colleagues in extending a warm welcome to you and your family. Congratulations on your nomination. I enjoyed sitting down with you recently and talking about your experience as both a lawyer and a judge and how that's molded your views of our judicial system. In the coming days, I hope we can have a candid conversation about your record and your judicial philosophy. As I told you the other day, these proceedings will be thorough but civil. As a member of this committee, I've had the opportunity to provide advice and consent on 7 previous Supreme Court nominations. This is number 8. I've seen the good, the bad, and the ugly when it comes to the way the Senate conducts these proceedings, and so have the American people. One of the best things I think comes from this process is I think this is a teachable moment that will remind all of us about the wisdom of the founders who wrote a constitution that made sure that our rights would be fixed and certain, so that these rights, whether they are the right to keep and bear arms or the right to practice one's faith, would be preserved from generation to generation. As you know, the founders established 3 separate branches of our government, a system of checks and balances, if you will. This was done for the purpose of preserving individual freedom and avoiding tyranny, and ensure that our government was ultimately accountable to the people, from whom all political power derives. Article 3, as you know, vests the Supreme Court and inferior courts with the judicial power. But the framers were very clear. The courts are not vested with a policy-making authority. According to our Constitution, courts hear cases and controversies and decide them. Nothing more, nothing less. That's an important distinction to remember in the days that lie ahead. Indeed, the framers envisioned that the courts would have a modest but very important role in our 3 branches of government. You'll recall Federalist 78, where Alexander Hamilton said the courts would have no influence over either the sword or the purse, and that it may truly be said to have neither force nor will, but merely judgment. Part of that judgment requires a judge to go where the law commands, whether or not you personally approve or not. And it starts with deciding cases as presented and not cherry picking the facts or the law and starting with a decision and then justifying it by the way, by cherry picked facts and provisions of the law. While the framers provided that the president would nominate judges, the framers also set up a framework that allowed judges, once you are confirmed, to exercise independent judgment, free from elections and politics. And so these Supreme Court confirmation hearings are really the only chance we have as representatives of the people to vet somebody who will serve the remainder of their life. Unfortunately, there are some driven by their ideology that want the Supreme Court to do more than what I've just described. These are some of the same people who tried to bully Justice Breyer into an early retirement. These activists demand that the court make policy and deliver results they can't achieve through the deliberation, compromise, and rough and tumble of legislative politics. And when the court does not deliver the results they want, they attack its institutional integrity and legitimacy. In recent years, these radical views have made their way into the mainstream. On the campaign trail, President Biden refused to disavow court packing. 2 years ago, the Democratic leader of the Senate went to the Supreme Court steps and threatened 2 sitting Supreme Court justices by name if they did not rule in a particular way. Dark money groups like Demand Justice have paid millions of dollars to promote court packing and sow public distrust in the legitimacy of the Supreme Court. Justice Breyer, as you know, recently warned of the crippling effect this politicalization of the court and its decision-making can have. He said, without the public's trust, the court would no longer be able to act as a check on the other branches of government and a guarantor of the rule of law, threatening the foundations of our constitutional system. Judge, I know you know that the courts are not designed to deliver particular policy outcomes or to invent new rights out of whole cloth. That's why it's imperative that we explore your judicial philosophy during this hearing. I will say I was a bit troubled that you have not so far provided us with much clarity on that matter. Someone as accomplished as you are, who spent years engaging and thinking about our Constitution and laws, has surely formed a judicial philosophy. This is not your first rodeo. You've had an impressive career, Judge, as a Supreme Court clerk, appellate advocate, and trial court judge. I like the fact that you've had such broad experience in our judicial and legal system. But there are still unanswered questions that remain. I'm a bit troubled by some of the positions you've taken and arguments that you've made, representing people who have committed terrorist acts against the United States and other dangerous criminals. As someone who has deep respect for the adversarial system of justice, I understand the importance of zealous advocacy. But it appears that sometimes this zealous advocacy has gone beyond the pale. And in some instances, it appears that your advocacy has bled over into your decision-making process as a judge. You've had some cases reversed, like all judges do, but some of them were particularly high profile when you ruled against a Republican administration. I'm eager to understand why in some instances you found that you could not decide a particular issue, while in other instances you enjoined a Republican administration from implementing its policies. I'm also interested, as others have mentioned, in your opinion, why pro-abortion, dark money groups like Demand Justice, and anti-religious liberty groups are pouring millions of dollars into a public campaign in support of your nomination. Judge Jackson, these are some of the questions and concerns I have. I assure you that you will have every opportunity to address these concerns as the committee evaluates your ability to fairly and impartially deliver justice should you be confirmed. So I welcome your testimony at these hearings, and I look forward to our give and take. Thank you very much.
Thanks, Senator Cornyn, Senator Whitehouse, Rhode Island.
Thank you very much, Chairman. Welcome, Judge Jackson. I could not be more delighted to have you here. This is a refreshing moment. We are holding a hearing for an accomplished, experienced, highly qualified nominee to the Supreme Court who came to us not through a dark money funded turnstile, but through a fair and honest selection process. Judge Jackson has unparalleled breadth of experience, both on and off the bench. She has already been confirmed by the Senate 3 times. She serves on what is often called the second highest court in the land. The DC Circuit handles some of the most difficult and consequential cases in the nation, often taking up questions that later come before the Supreme Court. Judge Jackson, that will enable you to jump right in once confirmed. Before the DC Circuit, Judge Jackson was a trial judge in the district court in the District of Columbia, ruling on hundreds of cases and presiding over trials, including many jury trials. Judge Jackson, you have presided over virtually every kind of case a federal trial judge can hear across criminal and civil law. You have more experience actually trying cases in your courtroom than any other member of the court. As a member of the U.S. Sentencing Commission, you helped establish the policies and practices for federal courts when deciding criminal punishments. With commissioners from both parties, you helped implement our bipartisan Fair Sentencing Act. Complicated and consequential work, and we thank you. It matters to me, Mr. Chairman, that Judge Jackson was also a civil litigator and public defender. She wasn't groomed in partisan petri dishes. She learned practical courtroom experience in both civil and criminal law. how the judicial system works and how it serves or doesn't serve different litigants. And I must say that in Rhode Island, we love that before you clerked for Justice Stephen Breyer, you clerked for Rhode Islander Bruce Selya on the First Circuit. Judge Selya was nominated by Ronald Reagan. He is well regarded by bench and bar, and he thinks the world of Judge Jackson. She is absolutely everything you would want in a Supreme Court justice, he told the Boston Globe in February. She has all the tickets in terms of her intelligence, her education, her work experience, and her demonstrated judicial temperament. He actually said that waiting for the Supreme Court selection process to take place made him feel like a father waiting to hear his daughter's college admissions results. We very much appreciate that Rhode Island touch to this nomination. Judge Jackson is steadfastly committed to the Constitution and the rule of law, and her record reflects the type of even-handedness and independence that will make her such a good Supreme Court justice. Her guiding principle, she has said, is to consistently apply the same level of analytical rigor to a case, no matter who or what is involved in the legal action. She says this means you can, quoting again, be consistent in the way you are analyzing the issues, and you can set aside any thoughts about who is making the arguments and what advantages any side might take away from your opinions. If you have fidelity to the rule of law that is grounded in looking at only those inputs, she said, then I think you can rule without fear or favor. Mr. Chairman, Judge Jackson will be an exemplary justice both because of the qualities that she possesses and because she did not undergo a secret pre-selection process to get here. She is before us on the basis of her own merit, not on the recommendation of a secretive right-wing donor operation hiding behind anonymous multi-million-dollar donations and aimed at capturing the United States Supreme Court as if it were some 19th century railroad commission. The unpleasant fact is that the present court is the court that dark money built. Anonymous donations funded the Federalist Society while it housed the selection turnstile run by the dark money donors. Anonymous money funded the dark money group down the same hallway as the Federalist Society that ran the dark money political campaigns for the selected justices. And because of all that secrecy, Americans are denied any real understanding of the overlap of all that dark money with the political dark money funding the Republican Party, which could well explain the wreckage of Senate norms, rules, and procedures that accompanied the confirmation process of recent nominees. Judge Jackson's nomination and the process by which she was selected stand in sharp contrast. President Biden undertook a thorough and independent review of her record, and she will proceed through a thorough and fair process here in the Senate. We will abide by the new precedents set by Republicans in recent years, but we will not be fabricating new ones. We've already seen dark money groups use dark money to run ads charging that dark money swayed this selection. We are hearing that again today. Ironic, when hundreds of millions of dollars in right-wing dark money built the current court majority and still signals its wishes through flotillas of dark money front groups posing as amici curiae. I welcome the debate on these points, and I look forward to hearing more from the excellent nominee before us. Judge Selya counted the late Justice Ruth Bader Ginsburg an old friend. I see some of the same qualities in Ketanji that I saw in Ruth, he said. Humility, the ability to inspire others in a quiet way, not at the top of her voice. Some people, he said, have the capacity to inspire by example and the force of their reason. Judge Jackson, I'm certain your capacity to inspire through force of reason will be on display here this week. Thank you, Chairman Durbin, for your leadership of the hearing, and thank you, Judge Jackson, for being with us today.
Thanks, Senator Whitehouse. Senator Lee of Utah.
Thank you, Mr. Chairman, and thank you, Judge Jackson, for joining us today. I appreciated the conversation you and I had in my office a few days ago, and your willingness to engage in a lively, interesting conversation during that. We'll look forward to more of that this week. I've enjoyed also meeting your husband and your two lovely daughters. They're wonderful people. I'm grateful to you for your service to the federal judiciary and as a member of the bar. You bring to the court, as I mentioned to you last week, a unique set of experiences. If you're confirmed, you will be someone who has served at all three levels of the federal judiciary. And as a result of that, you'll have a perspective that's different than that of most who have served on that court during the modern era. And I appreciate your willingness to be considered and to be here to talk to us about our questions. I echo what many of my colleagues have said today, in that I am dedicated, as I always have been, to making sure that these hearings are respectful. Engaging in the politics of personal destruction is not something we should ever aspire to. It is something that has occurred on this committee in the context of Supreme Court nominations. I'm pleased to say that it has never been under Republican leadership that such attacks have occurred, and I intend to make sure that this hearing is no exception to that. There are a few reasons for that. First and foremost, the most obvious is that respect to human beings requires it. Secondly, it's important because if we focus on personal attacks, that means we will be betraying our duty under the Constitution and to our constituents to make sure that we do our jobs fairly and properly. When we're focused on things that we have no business doing, like bringing forward spurious, last-minute, uncorroborated accusations of a personal nature, we neglect the importance of talking about the jurisprudential role, the philosophy that guides individual jurists, and the document that we're all sworn to uphold and protect, the Constitution of the United States. It's also important for an additional reason, a third reason. It has to do with the fact that having been nominated to this position, we know that you stand a very decent likelihood of ultimately being confirmed to this position, in which case you'll serve as a member of the Supreme Court of the United States. And I think it's important that even when, especially when, we disagree with decisions issued by that tribunal, we as a committee, as the Senate Judiciary Committee, not engage in speech or behavior that would undermine the legitimacy of the Supreme Court of the United States. You see, it's the legitimacy of the courts that gives them their potence, their power, their significance in our system of government. We all have a duty to make sure that we don't undermine that very thing that we purport to be protecting. Let me tell you some of the things that I look for when reviewing a nominee, and a few things that I intend to focus on in these hearings with you. One of them will involve any nominee's commitment to judicial self-restraint, to understanding the judicial role, what it is and what it is not. Any judicial nominee these days will acknowledge that he or she understands that the role of the judge is to interpret the law based on what it says, rather than on the basis of the judge's personal opinion. This is all very true. It raises questions as to how exactly that goes about and what steps, what tools, what rhetorical, linguistic devices the jurist in question might follow in order to do that. I'm looking for someone who is ideally going to echo something that Justice Amy Coney Barrett said in her confirmation proceedings, in which she likened the Constitution, this document written by wise men nearly 2.5 centuries ago. Wise men who I believe were raised up by Almighty God to that very purpose. To the extent we follow that document, it's helped foster the development of the greatest civilization the world has ever known. But she likened this and our commitment to it as a little like what Odysseus told his crew. She said the Constitution is like how Odysseus ties himself to the mast to resist the song of the sirens. She then goes on to explain that he told the crew, do not untie me, no matter how much I beg or plead, don't untie me from the mast. He wanted to avoid the tempting call of the sirens. The tempting call of the sirens is inherent. It's in government itself. It's understandable. And that's why we tie ourselves to it. Critical to that is the federal judiciary, the ultimate backstop, the backstop that's there to resolve disputes. Now, the Constitution isn't just something for the courts. It's not something that's owned exclusively and independently by the federal judiciary or the Supreme Court itself. But it does play an important role because the court's there to resolve disputes that arise within the court's jurisdiction as to the meaning of a particular provision of federal law, whether in the Constitution itself or as enacted into law by Congress. So we need a jurist who's willing to respect that role and demonstrate judicial humility. What I mean by that is an ability to acknowledge that there are a lot of things not within the province of the courts that entail policy. The job of the court of the judiciary is never to exert will or force. It is only judgment. It's discerning what the law says. A nominee also, I believe, needs to show a steadfast commitment to the principle of separation of powers. There are a couple of forms of separation of powers required by the Constitution along two axes. One operates along the vertical axis that we call federalism. It says most of the power of government within the United States, most powers that government might exercise are to be exercised at the state and local level. Power that's federal is the exception, not the norm in our constitutional system of government. The other form of separation of powers operates along the horizontal axis. It's one that recognizes within the federal government, which is limited, we're going to have one branch, our branch, Congress, that makes the laws. Another branch headed by the president, the executive branch that enforces them, and the third branch which interprets them, resolving disputes between parties coming before the court's jurisdiction. Third, I think it's important that a jurist within our system of government acknowledge the importance of interpreting the law as it was written, as it was understood by the public at the time of its enactment, if a statute or if a provision of the Constitution at the time of its ratification. This is part of how we tie ourselves to the mast, making sure that we undertake efforts to make sure that we're interpreting it based on how the public understood those words, regardless of the subjective intent of any particular lawmaker or group thereof. The public meaning at the time it became law. This is how we maintain the rule of law. This is part of how we've given force to this greatest civilization that human history has ever recorded. It's through the rule of law and tying ourselves to that mast. There are increasing threats to this. We've seen those threats arise with efforts to delegitimize the court, and I'm sickened every time I see or hear or experience one of those efforts to delegitimize it. We've heard some today, in fact, comments that I think by their very nature delegitimize the court. Another thing that can delegitimize the court are arguments made in favor of packing the Supreme Court. This was attempted by President Franklin D. Roosevelt in 1937. It did lasting damage to the court. It didn't succeed as a legislative matter. But it's arguable that it left a mark and not a pretty one. There is nothing in the Constitution that requires us to have 9 and only 9 justices. That is, under the Constitution, left to Congress's determination. But 9 is a number that works. It's worked now for 152 years. It's not one that we ought to revisit, and it's one that Supreme Court justices of various ideologies, including your former boss, Justice Breyer, whom I really enjoyed getting to know when serving as a law clerk on the Supreme Court. I enjoyed our conversations with him. He, Justice Ginsburg, Justice Thomas, and so many others have been against that. We must protect the court. We may not protect the court. We lose ability to protect the court if we allow arguments to take root that are focused on expanding that and turning the court into a political body. Thank you, Mr. Chairman.
Thanks, Senator Lee. Senator Klobuchar.